Good morning, Your Honors. The matter before the court this morning is the case entitled Hammond versus the University of Vermont Medical Center, case number 24AP303. Appellant Hammond is self-represented. Representing the appellee, the University of Vermont Medical Center, is Elizabeth Radigan.
All right, the appellant, please identify yourself for the record, and then you may proceed with your argument. You have 5 minutes.
My name is Zephyrin Aaron Jude.
You have to speak up.
My name is Zephyrin Aaron Jude Hammond.
I can still barely hear you.
My name is Zephyrin Aaron Jude Hammond.
Much better. Thank you.
You're welcome. I just wanted to mention that it's been about 6 years since I was terminated from the University of Vermont Medical Center. I was wrongly terminated at that. So this case was never the legal issues within this case that summary judgment. This case was not eligible for summary judgment motion until the evidence within this case was discredited and withheld from the record. Given the preponderance of evidence in my favor, I did turn all this evidence over during the discovery phase, which was just omitted maliciously, so that summary judgment could be motioned for, and a single judge would have the discretion of making a judgment based on the evidence that was produced. I did have direct evidence of the initial complaints that I made prior to any of the corrective action that I was given, which was withheld from the record. In the judgments that I was given by both judges, it clearly stated that there wasn't any evidence of any complaints made prior to receiving corrective action, which is not true. It is actually in a text message that I produced during discovery, which was weeks prior to that. And due to that complaint, the 10 months that followed were basically in retaliation for that one complaint. And I did have all the evidence, all that evidence that was withheld from the record. I motioned to have my case reopened April 24th, or April 2024, but I was denied again, even though I went through the entire record and I was able to all the evidence that was not produced originally for the summary judgment motion. I also have evidence proving the appellee's reasoning for my termination was in fact a lie. There isn't a single incident report within the documentation that I was produced in the record for summary judgment proving that I was responsible for any wrongdoing. And these write-up incident reports were imperative when keeping track of errors or any issues that employees did have, which again did not exist because I did not have any issues. Lastly, I was also in fact given the option to use scheduled time off on 4/1/2019. Therefore, I was not a no-call, no-show. This evidence too was also withheld from the record, making it seem as if I was a no-call, no-show. I had a discussion with my supervisor where she allowed me to come in if I chose to on 4/1/19, and I had chosen not to. She went behind my back and told HR that I was no call, no show. I tried explaining this, but I wasn't. I was basically terminated 2 days later. Excuse me. Again, I never admitted to the two allegations. One, the no call, no show 4/1, and having missed a specimen on 3/23. Although the published public record does state that I admitted to these two lies, in which I knew were lies, so I did file a lawsuit against UVMMC knowing that I was wrongfully terminated. Then the published public record states that I admitted to these, making it seem as if my case was meritless. This is unconstitutional and a direct violation of my Seventh Amendment right, which I've been fighting for, again, for nearly 6 years. Due to the lawyer misconduct of both sides, my lawyer and the counsel, the case was they are responsible for misleading the decision maker, having withheld not just evidence, but a preponderance of evidence in my favor.
All right, and you're going to have to leave it there. Your time has expired.
Okay.
All right, thank you. All right, counsel for the appellee, please identify yourself and your client, and then you may proceed with your argument. You have 5 minutes as well.
May it please the court, my name is Beth Radigan and I represent UVM Medical Center in this action. Appellant Hammond is seeking to reopen this case, reverse summary judgment, and add documents to the record that were all available to Appellant Hammond at the time that Appellant Hammond and their lawyer opposed summary judgment. The Superior Court correctly denied these requests, and this court should also deny and affirm the Superior Court's order denying their request. So, but the issue here is not to second guess the court's decision. This court's decision, we were here about 2 years ago making these same arguments, and this court affirmed the Superior Court's granting of summary judgment in UVM Medical Center's favor. And we're not here to relitigate that or re-argue that. Under the doctrine of law of the case, that's the law as decided by this court. But that's really not the issue. The issue here is whether the Superior Court properly denied Appellant Hammond's request to reopen.
The 60B, Ms. Radican, the 60B motion?
Yes, yes.
And that was based on that no additional new information, that everything was available from 2019, is that correct?
Correct. And in fact, Appellant Hammond has said today and has said in their papers that all of this documentation was available to their counsel, and they had them in their possession at the time when we were litigating this case at the trial court level. All of this documentation was available then. The issue, I believe, for appellant is they're unhappy that their lawyer didn't use all of those documents at that time. As it is firmly held, that's not a reason to have a second bite at the apple. When lawyers make tactical decisions to use or not use certain evidence, you're bound by that. You don't get to relitigate those issues. So there's nothing new. So under Rule 60B, there's absolutely nothing new that has been presented by appellant that appellant didn't have at the time summary judgment was filed. So there are some other miscellaneous issues beyond in the various aspects of Rule 60B. The motion's untimely for one. There's some allegations of fraud, and there are insufficient allegations for purposes of 60B, and there's certainly no extraordinary circumstances under the 60B6 catch-all rule. So there's simply no reason to reopen, and the Superior Court was correct, and we believe this court should affirm that decision.
How about in the interest of justice? That's another one in 60B.
Well, we have talked about this a little bit before, and the interesting thing is that some of the evidence that is cited by Appellant Hammond in their brief talks about documents that they believe should have been presented. But in fact, the Superior Court and this court actually dealt with some of that evidence. And if you look, I believe it's at note 3 of your decision from June of 2023, there's a reference to some accusations or some allegations by appellant that there was a text message claiming that there had been some evidence that they had made a complaint of racial discrimination early on. And actually, this court, as did the Superior Court, talked about that, and this court decided, and if I can quote it, that this oblique reference to past speculation between Courtright and Carpenter is not reasonably construed as a complaint by plaintiff of race discrimination or retaliation. So to get back to your question, justice has already been served, because those documents that allegedly contain this evidence that appellant believes will change the case, in fact, were considered, or the message and the information in the documents were considered at the time by this court and by the trial court. So not only is it not new evidence, it actually, the appellant was given the opportunity, and this court looked at what appellant's arguments were in connection with that. So there's no denying of someone's rights when the court has already considered those arguments and rejected them. The Superior Court also properly denied appellant Hammond's request to amend the answer under res judicata.
Right. And your time has expired, and you'll have to leave it there. Right. Thank you both for your arguments. The bailiff may call the conclusion of the case.
That concludes